We're going to give everybody a few more moments to join, but welcome to Martinez Law, Getting Real with Attorney Martinez. So wait just another moment. All right. Good morning, everybody, and welcome to Get Real with Attorney Martinez. Today's topic is deconstructing the Florida Land Trust. If everybody wouldn't mind muting themselves. This is an informal roundtable. After the topic presentation, we will open up for question and answers on any real estate topic you may have. If anyone experiences freezing throughout this presentation, please go ahead and disable your video to see if that helps. I'm Jennifer Canizzo, paralegal with Martinez Law. We have several of our team members on with us today. So we're going to go ahead and start with Attorney Thornton. Would you like to go ahead and introduce yourself?
Good morning, I'm Tiffany Thornton. I'm an associate attorney with Martinez Law, and it's great to see everyone this morning.
All right, thank you, Jennifer. My name is Cristen Martinez. I am the founder of Martinez Law. The law firm was founded back in 2015 as a full-service real estate law firm. The goals that I had at the time was, number one, to provide this service in the Wesley Chapel, Tampa Bay area community. I believe that at the time and still today, it is a service that is not readily available. The majority of real estate attorneys, in my opinion, or in my experience, have been either attorneys who own title companies, who do a little bit of law on the side, or attorneys that do real estate as more of a general practice. And I wanted to provide a law firm that focused solely on real estate so that we could maintain our status as the expert in the real estate community and the real estate legal community. And so one of my other goals in founding the law firm was to educate real estate professionals in the community. My practice is split up into two different sections, so to speak. One of the sections is transactional work, where we prepare contracts and lease agreements and help clients with asset protection. The other and much larger side of my practice is litigation. And so by educating the community and specifically real estate professionals, the hope and the goal is to keep you and your clients out of any sort of dispute or from having to call my office with a litigation matter. Litigation typically doesn't benefit any of the parties involved. Even if your side or your client wins at the end of the day, it's not a beneficial process in most cases. And so if we can draft airtight contracts, if we can educate you on the front end to try to avoid that process, that's what we want to do. So that's a little bit of background on me and the firm. Since our last Get Real with Attorney Martinez event, we have gone through some very exciting changes. Since our last event, Attorney Tiffany Love, who is not with us this morning, but she became named partner with the firm. We are now Martinez Love. We were formerly Martinez Law. And so we have been very excited and working on rebranding and growing the firm in that way. And so thank you all for joining us here this morning. I'm going to go into our topic very shortly, but as you have questions, and those questions can be on the topic that I'm speaking about or about anything real estate related, go ahead, you can put them in the chat, or once I'm done presenting the topic, you can go ahead and unmute yourself and ask me those questions. as Jennifer said, this is supposed to be an informal roundtable, so I'm here to answer any questions you may have. Certainly, if you have questions about the topic, I'm happy to address those as well. But I'm going to go ahead and jump right in. And so today we are talking about Florida land trusts, and I am going to see if I can. Jen, will you please enable me to share my screen? I do have a PowerPoint presentation, so I'm going to go ahead and once that gets working, there we go ahead and share my screen with you. Let's see if I can get. Okay, hopefully everybody can see that. And so Florida Land Trust for the savvy real estate investor. Land trusts are something that I recommend almost daily in my practice. I work with a lot of investors, whether they're doing wholesaling or fix and flips or holding on to investment properties and using them as rentals. That is probably the largest portion of my clientele. And so I'm talking about these and I'm recommending these all the time. And the consistent feedback I get is, you know, what is a land trust? I've never heard of them. How do they work? Why can't I use an LLC instead? And so I'm going to go through the nuts and bolts of what a land trust is, some of the terminology that I think is important to understand, what the benefits are of a land trust, and why, if you have any investment properties, you and your clients should be using them. So first, let's talk about some of the terminology. Florida, I guess let me back up. So I'm going to go ahead and just give you a little bit of preview of what I'm going to cover, and then I'm going to cover it specifically. I'm jumping ahead of myself a little bit here. So we're first going to talk about what is a land trust. Legally, what is the definition? What does it mean? Then we're going to go into the terminology of the different parties and the different documents involved in creating and using a land trust. Specifically, we're going to discuss the land trust agreement as well as the deed of trust. Those are going to be our two key documents. We're then going to talk about the trustee and their roles, the beneficiary and his or her roles, and then we're going to wrap up with why you should use a Florida land trust, what the benefits are, and then some practical considerations when using them. So first off, what is a land trust? A land trust is essentially a vehicle or a tool for holding title to real property. Land trusts are exactly what they sound like. It is a trust for the purpose of holding title to real property. You cannot put anything other than real property into a land trust. Land trusts act as a shield against personal liability for the beneficiaries, which we'll get into a little bit later, and provides ease of management for both individual owners and when you are looking to own property with another person or another entity. A land trust is a great tool for you to consider. And so, as I previously stated, there are two essential documents or instruments that are needed to form the land trust and then to transfer title of the property into that land trust. So you're going to have the deed, which is going to work to transfer title into the land trust, and then you're going to have the land trust agreement. Before I get into a lot of the substance, I do just want to go through some of the terms that you're going to see throughout the land trust agreement and that we're going to be discussing here this morning. The first one is that document that I have mentioned a couple times is the land trust agreement. This is the document that is going to create the land trust, and it is also going to define the powers and the authority of all parties involved in the land trust. So those parties are going to be the trustee and the beneficiary. When using a land trust, the trustee, it can either be an individual person or an entity, like a corporation or an LLC, but the trustee is the party who actually holds legal title to the property. So when you search for the property in public record, the property appraiser's website is going to show the trustee as the owner of the property. However, the beneficiary, which again can be an individual person or it can be any type of entity, a trust, an LLC, a corporation, the beneficiary has all the control. So they have the power to direct the trustee, to manage the property. They're the true beneficial owners of the property, and they are entitled to all of the income or sale proceeds from that property. The next term we have is a deed of trust. This is the deed that conveys title to the property from either an individual or another entity into the land trust. The reverse of that is called a trustee's deed. And this is when you are transferring property out of a land trust. So a trustee's deed, we're going from the land trust to another, either individual or entity. Okay, so let's break down the land trust agreement. The signatories to the land trust agreement are going to be the trustee and all of the beneficiaries if there's more than one. This is essentially a contract between the trustees and each one of the beneficiaries, where the parties are all agreeing to the powers and authority that each party has, the duties and obligations that each party has, and the management and control of the property. The land trust agreement is not recorded in public record. One of the benefits, one of the major benefits of using a land trust, which we will discuss in a couple of minutes, is that the true owner of the property, the beneficiaries, are allowed to remain anonymous. Their names and information are kept confidential. And so their name is going to be disclosed in the land trust agreement. For that reason, the land trust agreement by Florida law, by statute, cannot be recorded unless a court orders it to be recorded. The land trust agreement is also going to define the object and purpose of the land trust. So most typically, we're going to have the real estate being transferred into the land trust defined within that agreement, and also what the purpose of it is. And then finally, the land trust agreement is going to provide specific provisions for the limitation of liability for both the trustee and the beneficiaries. One of the benefits is that there is no personal liability for either the trustee or the beneficiaries when using a land trust. And we'll kind of talk about that benefit and how it works in a little while, but just know that those terms and that specific provision is something that will be included in the land trust agreement. Oops. Okay, the deed of trust. So this is the second document that is prepared in connection with creating a land trust and transferring title of the property into the land trust. The deed of trust can either be a warranty deed, a special warranty deed, a quitclaim deed. The differences in those terms are whether title is insured and clear title is guaranteed. And so if it is guaranteed, you're going to have some type of warranty deed. If it's not insured and guaranteed, it's going to be in the form of a quitclaim deed. The deed of trust is a very specific type of deed. Most title companies are not going to prepare these because by statute, when we're dealing with a land trust, the deed itself has to set forth and specify the powers and authority of the trustee. The land trust agreement, remember, is not recorded. So there is no public knowledge in the land trust agreement of who the trustee is and what powers the trustee has. Because that document is not publicly available, we have to include that information in the deed so that public notice is provided as far as who has the right to control and manage this particular property. It specifies in the deed of trust that the beneficiary's interest in the real estate is personal property. We'll talk about the significance of that in a little while, and that legal title is held by the trustee. Deeds of trust are very specific, and there is very stringent language that the statutes require be in this type of deed. And again, that is one of the reasons why title companies aren't going to prepare them. And that is a huge reason why my strong recommendation is that you have an attorney who is familiar with land trusts prepare this type of deed for you or your client. Let me make sure. Okay, the trustee. So the trustee is one of the parties to the land trust agreement. Important things to know about the trustee. Number one, as I have previously mentioned, the trustee has no personal liability for anything that happens with the property. So if somebody gets injured on the property and sues the land trust to recover for those injuries, they cannot get to the trustee's personal assets to satisfy any sort of claim for liability. The trustee can be a human being, an individual, or it can be a corporate entity. One important thing to note is that the trustee should not be it should not be the same as the beneficiary, and the trustee should not have any sort of apparent connection to the beneficiary, such as the same last name or any sort of identifying information that would lead somebody to assume that the beneficiary is connected to that trustee. The reason for that is to preserve confidentiality. One of the big benefits of a land trust is the confidentiality of the beneficiary. So if your trustee has the same last name as the beneficiary, that's going to be an obvious connection and some obvious dots that the public can connect in order to figure out who is behind this land trust. So we recommend that the land trust be, my firm is typically the entity that serves as trustee for most of our clients. But if you have a CPA firm that you trust, that can do that. If you have a close family member or friend who does not have the same last name as you that you trust to take on this role, those would all be great options. If you choose a trustee that is an individual, it is very important to appoint a successor trustee in the event that that individual becomes disabled and unable to perform their duties as trustee or passes away. There are ways to appoint a successor trustee after the fact, but it is much cleaner and it provides much better protection if you do that within the land trust agreement. So there's no hiccups and there's no question if something like that were to occur. The final thing to point out or to note about the trustee is that the trustee can only act upon written authorization of the beneficiary. So the trustee can only act when specifically directed to take that action by the beneficiary. And the trustee's job and duty is to act for the sole benefit or in the best interest of the beneficiary. And so a lot of times I get questions about, well, I don't want to give all of this power to a trustee when it's my property. That is why we have the land trust agreement, because it is very specific about limiting the trustee's ability to do anything without specific authorization from the beneficiary. Okay, so now let's talk about the beneficiary. There can be one, there can be more than one beneficiary. Again, there's no personal liability on the part of the beneficiary. So again, if there was a lawsuit filed in connection with the property, they would sue the land trust, and only the land trust's assets would be subject to that lawsuit. The personal assets of the beneficiaries would not. The beneficiary is the one, even though they're not taking the action, they're the one with all of the power and control over the operation of the property, whether to rent out the property, whether to sell the property, how much to sell the property for. They're making all of the day-to-day decisions regarding the management of that property. The interest of the beneficiary by Florida statute is to remain confidential and may not be disclosed without court order. Now, when purchasing a property, especially if you're getting a mortgage, there are going to be certain parties that know the identity of the beneficiary. Your title company is going to know. If there's a mortgage, your lender is going to know. All parties involved that have the identity of the beneficiary are required to keep it confidential. So it is almost impossible to purchase a property into a land trust without disclosing the identity of the beneficiary to anybody. But the key here is that that information can never be made public record absent a court order. The interest in the property that the beneficiary holds when using a land trust is legally defined as personal property versus real property. So personal property is your vehicle, jewelry, china, things that you own. Real property is real estate. However, when using a land trust, the interest in the real estate is defined and operates as though it were personal property. This is very important and very beneficial because how we transfer title to property held in a land trust is much easier when it's personal property versus real property. When you transfer real property, you have to use a formal deed. The signature of the owner has to be notarized and witnessed by 2 subscribing witnesses. There are all of these requirements and formalities that have to occur when we're transferring real property without the use of a land trust. Additionally, that transfer is made part of public record, and so taxes are going to be assessed on that new purchase price. With a land trust, the interest is personal property, so we don't have to use all of the formalities in conveying that interest in the property. The entire land trust can be sold, or just the property itself can be conveyed by a simple 1-page assignment of beneficial interest. We don't need a deed. There is no recording of the transfer or the new purchase price, so there's no reassessment of taxes, which in this market in particular can be very beneficial. So the fact that the interest in the personal in the real property is defined as personal property when it comes to land trusts is a huge benefit in the ease of managing the property, as well as it does provide a tax advantage to the owner and the future owner. Okay, let's talk about, I've touched on some of them throughout the presentation this morning, but let's talk about why I recommend these, why I speak so highly of them, why you or your clients should use a land trust if you have any sort of investment properties. The main one, which I've hit on a couple of times, is there's no personal liability. So when a client comes to me who either already owns investment property or is planning on purchasing an investment property, my advice to them is you need to hold title to that property in some sort of entity. My recommendation is a land trust, but if you're, dead set on using an LLC or some other type of entity, that's great. We can work with that. The key takeaway is it should never, ever, ever, ever be held in your individual name. It is far too risky. Another benefit there is no partition rights between co-owners. So if you are investing in property with a partner or with some other person, if you're holding title to property in the traditional way, not using a land trust, at any point, if there is a dispute that arises between the 2 co-owners, each co-owner has the right of partition, which means they can file a lawsuit and force the sale of the property at any time they want. With a land trust, that's not an option. So there is much better protection to the partners when using a land trust versus any other type of method. With a land trust, you do avoid probate. And so upon the death of the beneficiary, the property does not go through probate. The property is automatically transferred to the successor beneficiary, which can be named right in the land trust agreement. Anonymity, confidentiality, that is the main benefit, in my opinion, of using a land trust. Why that is so important is because when you have assets and people can look at the public record and see what assets you have, you become very attractive for lawsuits. So part of the analysis that I go through when clients come to me and say, hey, so-and-so owes me money, I want to sue them. One of the first things we do is we do background checks and research to see whether this person is even worth suing. If we sue them and win, do they even have any money to pay the judgment? You want it to appear from the public record that you have 0 assets and that it is not worth somebody's time and money to sue you. There's no annual fees associated with the land trust. So unlike an LLC or a corporation where you pay $125, I think it is, every single year to the state, you don't have that with a Florida land trust. The property is not subject to any sort of liens or attachments from creditors or judgments against the beneficiaries. The death, divorce, bankruptcy, any of those things on the part of a beneficiary does not cloud title to the property, which is very important. And then finally, the transfer of the interest that the beneficiary has in the property is by assignment, which we talked about previously, versus the formalities of a deed and recording the deed and all of those things. There are more benefits than this. These are the main ones. I don't have all day to go through. I would love to, but I'm sure you guys don't want to hear me talk for that long. But there are many other benefits. These are the main ones. If you have questions, let me know, throw them in the chat, shoot me an email after the fact. I'd be happy to talk more about these with you. If you can't tell, I'm very passionate about land trusts, and I think they're a great tool and a very underutilized tool. I want to wrap up with a couple of practical considerations when using a land trust. So one of the first questions I get when speaking with an investor or a prospective investor is, if I have more than one investment property, can I put several properties into one land trust? The answer is yes, you can. There's nothing legally prohibiting you from doing that. However, the best way to protect yourself is to create a separate land trust for each individual investment property that you own. The reason for that is, if you have a rental property and your tenant or a guest of your tenant gets injured and sues on that property, the entity that they have to sue is the land trust that owns the property. Let's say they have a claim for $1 million. And the rental property that you're occupying is only valued at $200,000. If they sue the land trust and the only asset in that land trust is the rental property that is the subject of the lawsuit, that tenant's liability is capped at $200,000. However, if that land trust owns 5 other investment properties and the combination of all of the properties equals a value of $1 million, that lawsuit can act as a lien and eventually result in foreclosure of all 5 properties in order to satisfy that tenant's claim. So we want to avoid subjecting other non-related properties to liability in association with one particular property. Operation and management of the land trust. This is another benefit, in my opinion. It can be done a couple of different ways, but the key takeaway here is with a corporate entity, so a corporation or an LLC or a partnership, something like that. Legally, you are required to segregate yourself as an individual and the owner of that entity from the entity itself. If you do not, you are at risk of waiving the protection that that entity provides you. So the best example of this is commingling funds. With an LLC, you cannot commingle income from a rental property owned by that LLC. You can't deposit those rent checks into your personal account. You cannot pay for expenses associated with the property out of your personal money. That is commingling, and that results in, the legal term is piercing the corporate veil, but that results in a waiver essentially of the liability protection that that LLC provides you. With a land trust, and another quick note on that, commingling usually happens by accident. It is not something that people say, you know what, I don't feel like opening a separate bank account. I'm just going to put it all into my personal and hopefully nothing bad happens. That's not usually the case. It's usually, oh my gosh, I got a call from my tenant at 10 o'clock at night. There's been a pipe has burst. We need a plumber out there. You scramble to call the plumber, and without thinking, you give them your personal credit card information. That's how it usually happens. With a land trust, you don't have that risk of waiving the protection that the land trust provides you. I still don't recommend you commingle, but if you do choose to commingle, or if you accidentally commingle funds, you're never going to lose that protection that the land trust provides you. So that is a huge benefit and a huge safeguard for you there. Finally, the term and renewal of a land trust. By statute, land trusts remain active for a period of 21 years. Unlike corporate entities, you have to renew them every year. If you don't renew them timely, they could be administratively dissolved, excuse me. You have to pay administrative fines and fees in order to reinstate it. You don't have to deal with any of that stress or additional funds and effort on your part every single year when we are talking about a land trust. I will now go ahead and open it up for questions. I believe, based on my agenda, I went a little bit past my time, but I will make sure to address questions as they come in. It looks like we have some in the chat, so let me stop my screen share. Okay, so first question we have is, if someone is purchasing new, does it change the mortgage process? Excellent question. A couple of points on this. My recommendation when purchasing a property that is going to be used for investment purposes is that we create the land trust prior to closing, preferably prior to signing the contract, but even if it's after contract signing, we can assign the contract to the land trust. Create the land trust prior to closing and close directly into the land trust. That is the best and the safest way to set it up from a timing perspective. Does it change the mortgage process? Yes. The mortgage will be taken out in the name of the land trust. 100% of the time, the lenders are going to require the beneficiaries of the land trust to personally guarantee or to also sign on to the mortgage. So it doesn't alleviate the beneficiary's obligation to sign personally onto the mortgage. That's still going to be a requirement. The mortgage process may be a little bit different because in the mortgage products that you can apply for might be a little bit different because you are using a land trust. But if we're talking investment property anyway, it shouldn't affect it from a substantive perspective all that much. Can this happen after ownership has been taken? So yes. My recommendation is we set up the land trust prior to closing. We close with the property going directly into the land trust. However, if you purchase a property, you close in your individual name, and you later want to transfer into a land trust, we can still do that. If there is a mortgage on the property, technically, there is a due on sale clause in your mortgage. And so technically transferring the property from your individual name into a land trust, that is a technical default of your mortgage. However, one way we can go about it is contacting the mortgage company and getting their consent and authorization to transfer the property. Since the beneficiary is going to remain on the hook for the mortgage, that's usually never a problem. A second option is transferring the property from the land trust into, from your individual name into a land trust with a mortgage on the property. While that is a technical default of the mortgage, I have never, in all of my years of practice, in all of my years of asking lender after lender after lender, I have never seen a lender call a mortgage due because of that technical default. The consistent answer has been, as long as we're receiving our payment every single month, we do not care. Number one, they're probably not going to know about it. Number two, even if they do know about it, they're not going to care as long as they're receiving their payment every month. And number three, worst case scenario is, let's say they find out about it. Let's say they do care. They're going to send you a notice and say, hey, we didn't authorize this. We don't want this property in a land trust. You have 30 days to change it back. That's not an ideal scenario, obviously, but the key takeaway here is they're not going to foreclose on the property immediately and the client's going to lose the home because they've transferred it. That's never been an issue. Most of my clients, I will tell you, go ahead and transfer it without getting authorization from the mortgage company. I've never seen it be an issue, but I've never seen getting consent from the mortgage company being an issue either. So those are the two ways you can go about it. Okay, Anita asks, can you put your personal home in a land trust? Yes, you absolutely can. With your personal residence, the home is already protected from liability from your creditors or judgments or anything like that due to the Florida homestead protection. So you don't need to put it into a land trust for that purpose. However, I do have clients that put their primary home into a land trust for confidentiality purposes. Usually this is when the primary home has a very high fair market value. So if I do a public record search and I see you have no assets, nothing comes up for you, but I see you own a $2.5 million home, I'm assuming that you're probably going to be worth my time to go ahead and sue you. So yes, you can use land trusts for your personal property or your personal residence. Okay, what is the cost to have your firm create this for a client? So if you've been following me for a while, you know that my firm is now doing everything on a flat fee basis. So I can actually answer that question without having to say it depends. So for the package, it's a flat fee of $1,000. The preparation of the land trust agreement is a flat fee of $750. The deed is a flat fee of $250. So the package is $1,000, and included with that comes as many consultations, phone calls, meetings with me as is needed with the client to make them feel comfortable, that they know what they're signing, they know how it works, and then as well as advice on how to manage the property moving forward. That also includes having my firm serve as trustee if that's what's desired. Another note on this is once a land trust is created, you can use it over and over and over again. So I have clients where they will create a land trust, hold a property for a year, flip it, sell it, and then buy another property and put that property into the original land trust. In that case, all you need from me is the deed, which is a flat fee of $250 once that land trust is created. David asks, are there downsides to a land trust? That is an excellent question. I conveniently skipped over that because I'm such a huge proponent of land trusts. The main one that I see come up is not very many people in the industry are familiar with them and are as comfortable using them as they are LLCs. So I have gotten kickback from mortgage companies before where I've had to get on the phone and just explain to them. I've had some issues with title companies come up sometimes regarding some specific issues within a transaction that they need me to just explain how it works because they're unfamiliar. I have had sometimes to get on the phone with the title company's lawyer just to explain, you know, yes, we transferred it because it's personal property by assignment versus deed, and that's okay. And here's the statute that says that's okay. So those are the hiccups that I've seen. I'm almost always able to get them resolved. I do see sometimes as well, banks. There are certain banks that I have seen flat out refuse to create a bank account in the name of a land trust. There are many who do it. It is not necessary to have a separate bank account in the name of the land trust. Create a separate bank account in the name of the beneficiary and just run it through that way. So those would be the downsides, are the unfamiliarity in the industry with them, and people's, they just don't know how they work and how to use them. So there is some work as far as educating them that I've had to do at certain times. Do you offer a discount package for several land trusts created at the same time? Officially, the answer is no. I don't have, you know, if you're getting 3 land trusts, it's this type of discount. If you're getting 4, it's no, but I can tell you if you're getting more than 2 at one time, I almost always discount that. And so that's going to depend, there's my, it depends answer for you. That's going to depend on the complexity. Are there, you know, is every single trust going to have wildly different trustees, successor trustees, beneficiaries? They have 10 different heirs that they want the property to go to in the event the beneficiary dies. It's going to depend on the complexity of each transaction. But almost always, if it's more than 2, I have reduced the fee on those. Okay, excellent questions. Thank you so much for participating and for asking these questions. Feel free to ask additional questions on land trusts, on anything else that you may have. I will go ahead and preview for you. And Jennifer, I'm sorry, I know this is your portion of the agenda, but I'll go ahead and preview our topic for next month's. Yes, David, go Noles. It is football season, finally. Big game on Sunday. Thank you. I'll go ahead and preview for you our topic for next month's Get Real. It is going to be the top 5 mistakes that realtors make on the FAR bar contracts. Yes, I see lots of mistakes come through my desk when I'm either reviewing contracts before the fact or when I have an escrow dispute or a contract dispute and I'm reviewing the contract. And unfortunately, there was something that, if done differently on the front end, could have probably avoided the dispute. So I don't want any of you to be in that situation. So we are going to do a presentation next month on the 5 biggest mistakes that I see and how to avoid those and fill out an airtight contract so that you're protecting both yourself and your clients. Last call for questions. If not, Jen, I will let you go ahead and close out our session.
Apologies, I was muted. If there are no further questions, then we just want to say thank you so much for attending today's Get Real with Attorney Martinez. If we look forward to seeing you next month, Wednesday, October 6th. As a reminder, these are held the first Wednesday of every month at 10:30 a.m. next month's option will be in person or via Zoom. Sorry about that. So we look forward to seeing you then. Register on Eventbrite and send us any questions. I'm going to go ahead and put our email address up. I see Kristen already did it, but I'm going to
I
put
did
it.
that to you directly. Will you put it in the chat? I did it wrong.
All right, I'm going to put our email address in here so that if anybody has any further questions or, want to reach out to us, they can. So again, thank you all.
One last thing, Jen, before you sign off, there was a question. Is this recorded to watch again? Yes, these are recorded and they are reposted on our YouTube channel. So if you just search Martinez Love on YouTube, that should come up and all of the recordings from these events should be there for you.
All right, everybody.
Thank you, everyone.
I'm just typing this.